Thomas Willis. The file number is 1618016FY. Mr. DJ Hilson is here representing the people of the state of Michigan.
Mr. Brian Hostica is here representing Mr.
Willis. This is the time and the date set for a motion brought by defense. Go ahead, Mr. Hostica.
Thank you, Your Honor. Your Honor, this is the defense's motion for substitution of judges, and it's based on the fact that this disappearance of Ms. Herring happened in April of 2013, and I believe Your Honor wasn't appointed to the bench until sometime late in 2015. 14, okay. Well, at the very least, it was going on, the investigation into her disappearance was going on for over a year, during which time Your Honor was serving as the chief trial attorney in the Muskegon County Prosecutor's Office, obviously Mr. Hilson's office. And Your Honor, I'm not going to stand here today and accuse the court of having any bias or any impropriety regarding this case at all. But the fact that this is such a high-profile case and it's been going on for so long, and with your position in the prosecutor's office, the only people that know what your involvement in the investigation was in this case is between you and Mr. Hilson. So there is the appearance of impropriety, Your Honor, and that's why our office has brought this motion. Canon 2 of the Michigan Code of Judicial Conduct specifically says that a judge must avoid not only all impropriety, but the appearance of impropriety. And there's case law that we've cited from the Michigan Court of Appeals, as well as the United States Supreme Court, which do support that notion, Judge. So due to the length and the profile of this investigation, while you did serve in the Muskegon County Prosecutor's Office as the chief trial attorney, the appearance of impropriety is there, Your Honor, so we are respectfully requesting a substitution of judges in this case. Thank you.
Mr. Hilson.
Thank you, Judge. Certainly, as I was the elected prosecutor and ran the office, I can say as that in that capacity and as an officer of this court that you were never a part of the task force. In fact, I had assigned that role and responsibility to Matt Roberts, who was a senior assistant at the time, and now serves as the chief trial attorney here in Muskegon County. Mr. Roberts attended every single briefing with the task force. He was the liaison between the prosecutor's office and the task force that was working at the time. And I can very comfortably say this, during that 2-year period between the time of her disappearance to the time of Mr. Willis's arrest, our role during that time period was really supportive. If they needed legal advice, we were there to give it. If for some reason there was enough to jump on and do a search warrant, we were able to do that. But Matt Roberts was the individual that had that contact. And quite honestly, the office in general didn't really get fully involved or immersed in this whole investigation again until after Mr. Willis was arrested. And then we engaged the services of myself and other assistant prosecutors to assist in helping investigators move that investigation forward. So my recollection, Judge, is that I never assigned you to any part of that investigation, that Mr. Roberts handled that. And from my understanding, from my conversations with investigators over the last couple of months, they don't even recall seeing you at all during that investigation, or never consulted with you. The court's memory may be different than that, but from my investigation, once this motion was brought to my own recollection, and my own orders for that matter, you had no contact with this investigation or investigators at all. So I don't think the court holds any inherent information.
Mr. Hilson, I want to confirm a couple things that Mr. Hostica said. I certainly was employed in the prosecutor's office from 1992 until September of 2014, when I was fortunate enough to be appointed to the bench. My memory is that in April of 2013, I was employed as a senior assistant prosecutor. I wasn't promoted to chief trial attorney, I think, until June of 2013, after Mr. Bader had left.
You know what, Judge, now that you say that, you may be right. I'd have to go back and look at the personnel records, but Mr. Bader was probably still in the office at the time and still serving in that capacity.
For that period of time, I think Joseph Bader was the chief trial attorney, but it was in a transition period, and I shortly thereafter was appointed as chief trial attorney, Mr. Hostek. I will confirm that. But I was in the prosecutor's office for 22 years and handled many, many cases on behalf of the people of the state of Michigan. I was proud to do that. But this was not one of those cases. At the time of this event on April 26th of 2013, it was an abduction case. My memory is that Mr. Roberts was assigned to this case, Mr. Hostek. I can tell you, based upon my memory, I never gave anybody legal advice. I never provided any consultation whatsoever at any briefings. I never was involved in drafting or even advising on a search warrant in connection with the disappearance of Ms. Herringa. And so that's where I stand on the issue of my involvement. So with respect to the motion and brief that was filed, I do respect your position, Mr. Hostek, but I will not allow forum shopping on the mere allegation of an appearance of impropriety. I would indicate that I've reviewed this brief that you filed in Crampton versus the Department of State at 395 Michigan 347. It's a 1975 case, at which time the Supreme Court noted situations to include requiring disqualification where the judge has some pecuniary interest in the outcome. I never have or had a pecuniary interest in the outcome of this case. It also outlines a factor where the judge has been subject to personal abuse or criticism from a party before him. That's not even applicable in this case. The third factor outlined in Crampton is where the judge is enmeshed in other matters involving the complaining party. I'm not enmeshed in any matters involving the complaining parties other than the judge assigned to this case. And the fourth factor, and this is what is italicized in your brief, so I can only assume that this is where, with emphasis added in your brief, that you are indicating where there may be some appearance of impropriety. It says in the Crampton case, where the judge might have prejudiced the case because of having previously acted as an accuser, fact finder, or an initial decision maker. And they cite Crampton in your brief. I have never been involved as an accuser, fact finder, or initial decision maker in any capacity in this case before I was appointed to the bench. I never had any previous involvement as a prosecutor. So where you go on to cite the United States Supreme Court case, that's all premised on the supposition that I was involved as a previous prosecutor. I never had any involvement as a previous prosecutor. And that case talks about disqualification of the judge where the judge has personal knowledge or an impression of the case as through his former role as a prosecutor. I had no personal knowledge of the case. I had no impression of the case outside what the media was covering and the general public knew about the case. Your argument is based upon a number of paragraphs, and they all are really craftily worded with the words likely or believed to have this information. And I simply have to say this, Mr. Hostek, that I just don't have any personal knowledge, didn't gain any personal knowledge about this case as a senior assistant prosecutor or in my former position as a chief trial attorney. And then you cite Michigan Court Rule 2.003 C1 C and D. That's 2.003 parents, capital C, closed parents, 1 parents, lowercase c and d, where disqualification is warranted where the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. I have none. And where the judge has been consulted or employed as an attorney in the matter in controversy. I never was consulted or I never was employed as an attorney in the matter in controversy before this court. Also, there's an assertion that I, as chief trial attorney, in my role there, that role included attending informational briefings and signing search warrants. Do you have any direct knowledge, because I have not, Mr. Hosticott, I just want to make sure, do you have any direct knowledge that I attended any informational briefings? My knowledge is I did not attend any briefings on this case.
Your Honor, our brief is based on information and belief, and I think it's stated in the brief. No, I do not have any personal knowledge whether you attended any briefings or
Yeah.
not. But we're talking about a relatively small office in an extremely high-profile case. And it's our assumption that the case was discussed among the prosecutors in the office in which you served.
All right.
The office in which this case is being prosecuted. That's all. We're talking about the appearance of impropriety, Your Honor, and we're citing the judicial canon 2 as our chief reference.
And I respect that, Mr. Hosticott, before you sit down. You also assert that I signed search warrants in this case. My knowledge is I signed no search warrants. I didn't participate in the drafting of any search warrants, and I signed no search warrants. Do you have any information that I did?
No, Your Honor, I do
All
not.
right. So this is all on assumption then?
It's based on information and belief.
Yes. But there is no information that you have, other than the fact that I was employed in the office at the same
Correct.
time? All right. Well, I would analogize this, Mr. Hosticott, as similar to your office. You have a number of attorneys in the public defender's office, of which there may be a conflict between the lawyers that handle the family court matters, the delinquency and the abuse and neglect matters, and those are divided from the criminal cases, and you maintain a division in your office, do you not?
We do.
And you do that to avoid the appearance of impropriety and any conflict of interest, is that right?
We do.
All right, well, I can say this, that in this case, at the time that I was employed in the prosecutor's office, I believe there was at least 15 lawyers working on a plethora of cases that were occurring at the same time. I think I was enmeshed in a series of homicide investigations through the use of prosecutor investigative subpoenas at the time. And I had at least 4 or 5 homicide investigations going on at that time. Is that right, Mr. Hilson?
Judge, yeah, your memory is correct. We were working on at least 2, if not 3, open homicide investigations.
And
I know-
you had assigned me, I think, to conduct
Yes,
investigative subpoenas on a number of those active homicide investigations that had nothing to do with the Harrington case.
That's correct.
All right. That's my memory, Mr. Hosticott, and so with all due respect, I simply was not involved in this case in any of its matter, in any capacity. I did not give legal advice. I did not provide consultation. I wasn't employed as an attorney. And I didn't assist in drafting or giving consultation in drafting any search warrants in this case. I had a number of things on my plate at that time that involved a number of other active homicide investigations. And so I respect your request, Mr. Hosticott, but I simply am going to follow the law in this case, and all the factors outlined in that Crampton Department of the State have been addressed, and I simply cannot say that there's any appearance of impropriety, especially when I have had absolutely no contact with this case. And I'll say this, Mr. Hosticott, in connection with the Rebekah Bletsch homicide, I do distinctly remember being involved in a briefing after that homicide case. And I promptly disclosed that to the parties, and Judge Klute sat on that preliminary examination. Just for that reason, or I was actually on vacation that week anyway, planned vacation, so it worked out that way. But I disclosed where I knew I had some contact with the case, although I didn't think it was of any substance. It was prior to Mr. Willis being involved as a suspect in that case. But in this case, I just have to simply say I have no involvement in the case at all, Mr. Hosticott. So I respectfully decline to grant your request.
Your Honor.
Now, the parties had brought a matter before the court regarding tomorrow's preliminary examination. Mr. Hilson.
that's right, Judge. Mr. Hosticott and I had an opportunity last week to talk about the preliminary examination set for this week. As I indicated to him I myself am still awaiting some investigative reports to be turned over. So I have nothing to turn over to Mr. Hostiga in preparation of that preliminary examination, because I don't even have it. And I told him this morning that part of what I want to do is get a hold of, I talked to the investigators about that last week, indicated them the importance of that, and I'm going to continue to have those conversations with investigators. I'm hoping to get in my hands this week sometime reports that I can then turn over to Mr. Hostiga so he can prepare just like I can prepare. Based on that, Judge, we had signed a stip in order to adjourn tomorrow's prelim, which Mr. Hostiga did sign, which I did sign, my understanding is the court has signed it as well. And I'm looking for about 3 weeks, if that's possible, for the next hearing date.
Mr. Hoska, is that all accurate information?
That is accurate.
Is 3 weeks adequate time for you?
I believe so, Judge, depending on when the reports come to my desk, but it should be.
Right, the reason I raised this, and it was submitted to the court in a written stipulation, and I agreed to it, but I knew Mr. Willis was going to be here, so I wanted to address his right on the record while we had Mr. Willis in court. Mr. Willis, if you can please stand. Mr. Willis, you understand what's happening here today?
Yes, Your Honor.
All right, Mr. Willis, the prosecutor and your attorney, Mr. Hostiga, have requested the court to adjourn the preliminary examination that's set for tomorrow. I'm okay with that, to give the lawyers time to prepare. Your attorney's asking for that additional time as well. But this affects a right that you have under a statute in Michigan that gives you the right to have a preliminary examination held within 21 days of your arraignment on the charge. You understand that?
Yes, Your Honor.
And by adjourning the preliminary examination scheduled for tomorrow would necessarily take it outside that 21-day time period. Do you understand that?
Yes, Your Honor.
And do you agree to that?
Yes, Your Honor.
All right. All right, well, then I do find that the waiver of having the preliminary examination held within 21 days is voluntary, understanding, and with knowledge made, with the advice of counsel. And so I will grant the joint request to have the matter adjourned. I believe we have some time that we could hear this, and I'm going to give you a half a day, as requested previously, and that will be on October, are we at 20?
October 25, Joe.
October 25, on Tuesday, October 25, are we at 1:30?
We could do any time that works. That whole day is blank at this point.
All right, why don't we set it at 9, why don't we set it at 9 a.m.?
Okay.
And then that gives us an entire day to work with.
Right.
So we'll set it October 25, 2016 at 9 a.m. and we'll give you the entire day.
Thank you, Judge.
Mr. Hilson and Mr. Hostiga, that's what you're asking for.
Yes, sir. Thank you.
Your Honor. Yes.
You're welcome. Anything else, Mr. Hostiga?
No, sir.
Thank you very much. Mr. Hilson?
Thank you, Judge.